Good day, ladies and gentlemen, and in particular, clients of CTB. It is a privilege to have you online today. I have the privilege of taking you through the Protection of Personal Information Act at a very high level, and certainly touching on pertinent points of the legislation to aid yourselves, not business only limited to the financial services industry, but also any business that is involved in the use of or processing of personal information in respect of their clients. Clients could be retail clients, individual to individual. Clients could be business entities. It could be details relating to business strategies, thoughts, ideas, ideologies, and so forth. But anything and everything that can be deemed to be personal information in the construct of the Protection of Personal Information Act must be dealt with accordingly in terms of the obligations set out to comply with the provisions of the lawful processing of personal information. So I do thank you for your time in advance. I'm going to reflect on the agenda that we will have for this session today. And more specifically, I'm going to touch on critical points that come up in the agenda. We're going to look at specific definitions. We're going to look at worldwide data privacy regulations compared. We're going to deal with the 8 conditions of POPIA, in particular with reference to lawful processing of personal information as directed by those 8 conditions. Then we're going to look at various components of a business response plan that one could construct, which is operationally aligned to the business, your business in particular, and again, not businesses limited to the financial services industry, but all business involved in processing of personal information, notwithstanding the necessary security and safeguards that are required to protect the information in the possession of business or responsible parties or the processors of information, or operators of information. So those are some of the terms that we will deal with when we are talking about some of the key definitions we believe that we will reflect on in this presentation, but certainly not an exhaustive list. And then trying to deal with some of the practical parameters that may come with the items operationally and functionally in an organization that will aid your response plan in terms of meeting the compliance standards set out by the regulations. Now, it is important to understand at this very early stage that the legislation is not prescriptive in terms of what specifically business must do to comply or how you should do it more specifically, but it is important to understand the provisions of the legislation and make sure that through the compliance framework which you will adopt for your organizations, that you articulate an appropriate, a business appropriate risk management response plan in respect of the provisions of the Protection of Personal Information Act. So from that perspective, it's always important that we are able to deal with items practically. We draw back our conversations to a risk-based approach in the risk management processes and procedures that apply to any organization or strategy to ensure that you're not unnecessarily exposed in the event there should be a risk event that occurs due to non-compliance as a result of certain parts of legislation or multiple pieces of legislation that may need to be complied with. On a very high level overview, here is a reference to the various chapters held within the legislation. So lots of definitions and the purpose of those definitions. There are application provisions, but without going into all of them, we will be touching on the key provisions through this presentation at a very high level, and aid you in a point of departure or helping you communicate a point of departure through your task teams in the organizations that will be involved in constructing your response plan in relation to POPI, if you haven't already done so. Perhaps you've already done so, and the learnings from this presentation will help you enhance your response plan, but it's important to understand the various provisions that will come with that. So we'll deal with conditions for lawful processing. We'll deal with supervision, we'll deal with prior authorization, we'll deal with codes of conduct, transport of flows of information, rights of data subjects in general, offences, penalties, and administrative fines, should there be an event of non-compliance. But on an ongoing basis and in no particular order at all, we will deal with high-level practical engagements in terms of the Protection of Personal Information Act to guide you as a business into your response plan if you haven't yet committed to one as yet. Or alternatively, you are reviewing yours and you are bringing it up to speed with the latest provisions of the regulations. On a very high level, and certainly not an exhaustive list, we felt it necessary to deal with some of the key components or key definitions that are found in the legislation. We are going to be talking to personal information and what that is, the roles of a responsible party or operator. We're going to talk about what it means to process information in its definition, and then a record. We believe that these, in our independent opinion, are certainly the probably the starting point, the point of departure, because once you understand what these items deal with and what role you as an organization or individuals of the organization will fill, so you be in a position to then understand responsibility, understand where accountability lies, but also understand by definition where your response plan must begin. So I think the first thing that's most important is to understand what is personal information, and really it is any information in respect of a data subject. It could be race, gender, marital status, health history, contact information, biometric information, as well as so far as to go and talk about personal opinions, thoughts, ideas, ideologies. Take that as far as you would practically like to or enable to in the construct of your organizational classification of the data that you process in respect of your clients or customer set. So you can expand on this as long as you may need to determine what is personal information that you are using on a daily basis. So that becomes quite important. You've got to have a practical understanding what information you're collecting. Is it deemed to be ordinary personal information, or is it also potentially deemed to be sensitive or special personal information, because there are different categories of personal information that you'd be processing from time to time. So when we talk about process or personal information specifically, it also helps to understand processing. Processing is pretty much anything that includes any action or activity that can be done with the use of personal information. So it's any action or activity in respect of personal information: copying, filing, destroying, receiving, collecting, transferring, sharing information, storing information. So we mentioned collecting in this particular definition, but collecting itself can be argued as to whether or not it might be processing of personal information or not. But once you collect information, you've actually got to do something with it. And the likelihood is that you're going to store it, you're going to add it to a database at some point in time. And on that basis, you're already triggering the response in terms of processing of personal information. So you have and collect personal information, ordinary or sensitive or special personal information, and then you do something with it. And the moment you're doing something with it, you're effectively processing personal information. And one would need to get to a point where you're understanding the 8 conditions for lawful processing of information, that your response plan as a business is then able to respond accordingly and keep you in a lawful position as far as processing of that information is concerned. In the construct of the regulations, we are dealing with definitions relating to responsible parties, and ultimately, by its very definition, a responsible party is a person of senior authority and instrumental in a business who sets out the purpose for the information being obtained and the processing thereof. And this could be in the form of a public or private body. There is also the definition of operator, which is really a person who processes information for a responsible party in terms of a contract or mandate concluded between the parties, but without the operator coming under the direct authority of that particular party. And it is true that at any point in time, any business that is involved in processing of personal information could take on the role of a responsible party or an operator, or they may need to consider the possibility that there's joint responsibility in those two roles or functions that may exist. So if I use a basic example where an employer has an employee or workforce of 100 employees, the employer, and in particular the HR function, would be the responsible party as far as that employer is concerned in respect of the information it holds or has in its possession of its employees. Ultimately, the responsible party of the business, i.e. the employees, and therefore the information held or the information in possession of the company as far as the employees are concerned, would be the executive leadership of the organization and ultimately the CEO, if a CEO exists in that designation. It could also be the highest level of authority in a business. It could be a managing partner, it could be a managing director, could be a chief operations officer, depending on what the highest role in the executive leadership is ultimately responsible for the information that is being used in the business and the purpose that it's being used for. So it is important that as we go through this, we also then understand what a record of information is, and that is any and all information irrespective of the format in which it is recorded, not limiting to electronic or hard copy files held by the responsible party. So right throughout the organizational structures, one would need to get to a point where you're understanding at any point in time, any juncture, where you would find that information exists in respect of a data subject. Now, by definition, a data subject is both you and I. It could be your customers. It could be a prospective customer that you have on a marketing list. It could be a referral that you get through a existing customer or a family or a friend. It could be a business entity for that matter. And at any point in time, any one of those classifications would be a data subject, and information that you may have in your possession or may use in order to do more business or in order to service clients, ultimately is then processing information in respect of a data subject. So it becomes important that you understand right through your organization, both practically and operationally and ultimately functionally, what is required in the business, why you're processing that information, how you're processing it, and what are you doing with it once it is done, once you've taken action and process that information in respect of the use of that information, and then ultimately you do something with it. You store it for statistical purposes or research purposes. You store it for a requisite period of time because of other laws that are imposed on your organization in terms of record keeping obligations, perhaps. But there are reasons why you would hold on to information, perhaps in some cases longer than one should. And it's important that through the response plan, your compliance framework, your risk management plan, as far as the response to the POPIA regulations goes, it's important that you understand why you're doing certain things, why you're taking certain actions, and how you're doing it lawfully. And if for any reason you're finding yourself in breach of a particular obligation set out in terms of the legislation, it then becomes important to prioritize that piece, that particular regulatory item, and then afford a further response or an improved or enhanced control as to responding lawfully in the construct of that particular item of the legislation. So it becomes very important that right throughout there is an evaluation across the business, business documentation that might be used, interactions with customers, that there may be the conclusion of contracts or mandates, etc. But in any particular instance, the purpose behind the regulations is, number one, to ensure the rights to privacy in respect of the clients or customers that you might be dealing with. And number two is the safeguarding and lawful use of that information that you may be using in respect of that customer or prospective customer or client or business that you might be dealing with at any point in time. And that's the response plan that is sought after in terms of the particular regulation. So your best defense in terms of the regulations will always be obtaining consent in respect of the client or business entity that you might be dealing with. And consent could be in writing. It doesn't have to be. It's not prescriptive that consent must be obtained in writing. It is obviously your best defense that a written agreement of sorts confirming or validating consent be your best defense, be the safeguard that you're looking for in the event that there was a complaint against your organization for potentially using information without permission or unlawfully against the regulations that are set out in terms of POPIA. So your best defense will always be consent. However, it remains on you as the responsible party or the operator using that information to be able to demonstrate and prove that you have got permission to use and process the personal information of a data subject. And we'll touch on a few of those ideas, perhaps some legal concepts, and perhaps where those legal concepts may be seen in the future. But right throughout this, we're going to do our very best to try and give you some practical guidance at a very high level. It should be noted that upfront that no one business will respond equally the same in terms of the construct of their response plans or their compliance frameworks or their risk management plans as required by POPI. But it is important that on a practical basis, you're able to understand what you're doing in your business and how you're responding in terms of the regulations. We thought it'd be interesting at this particular point in time to share with you a comparison from the worldwide data privacy regulations as we compare them. I must state early on in the session that the Compliance Toolbox has attended a number of webinars from multiple service providers, and ultimately what we've done to give you the content here today is to try and bring together a culmination of the general information that is out and available in the public domain. And for our clients to CTB, we've chosen to do so on a non-chargeable basis. But really what's important here is we thought it'd be critical to have a look at what is the need. You know, everybody that we've been talking to has said to us, what is the need? Why do we need to have an information officer or a data protection officer? Well, the legislation and the construct of the regulations make it mandatory to do so. And as you can see worldwide, pretty much it is mandatory to have, in the context of the international jurisdictions, a data protection officer is mandatory in most of the jurisdictions. In South Africa, we're calling it an information officer, which will form the role of not only the information officer, but the data security officer as well. Data security officer as well as would be the construct in most organizations. And it's likely that there will even be the appointment of a deputy information officer, where your information officer will have the ability to delegate certain responsibilities, but remain accountable. You can always delegate responsibilities in terms of actions that are required to control the response plan in respect of POPI, but you could never delegate the accountability. So the appointed information officer of any organization will ultimately maintain accountability and retain the responsibility that is set out by the role, but it is a formal appointment that is required inside an organization. And if there is the absence for a formal appointment of somebody, ultimately the default of an information officer would rest on the chief executive officer or the highest level of executive leadership inside any organization, or the highest seniority or lead of the business, depending on the size of the business that there is. You know, sometimes you only have a business that is has 2 or 3 people in it. Other times you have business that have got 150 employees in it. So the magnitude of the regulations is more significant on smaller, medium, and then large businesses, depending on the complexity of those environments as well. We may even find some businesses with multiple information officers in designated areas of various businesses. So that becomes quite an important conversation, but nonetheless, it remains mandatory to appoint and register your information officer with the regulator's office. What we also found very interesting was to compare the fines or penalties in the event that there was the consequence of a breach identified in relation to the regulations. So it could be a case of somebody having knowledge of their information being processed. They claim not to have been given not to have given permission, not to have granted any consent, and for that reason, their information should not be used by you or a representative of the organization or your business altogether. And they now make a complaint to the regulator's office, and then there is an inspection. What we did find was very interesting, that the significance of the fines or penalties that are possible worldwide are much more significant than they're currently pinned to be in South Africa. And it is our independent opinion, and I mean, this truly is our independent opinion, is that we believe that the fine or penalty in South Africa of 10 million rand or 10 years imprisonment is perhaps a bit light in the context of the legislation, and we expect, or at least it is our sense, that it may be possible that over time that 10 million rand may become much more significant in the context of the regulations, where a breach or an unlawful processing event is taking place, and largely if there was non-cooperation from the parties involved, and the complexities are more specific. But outright, if there was a breach and there was a fine involved, we expect that over time, over years to come, we may expect that 10 million rand could potentially come in line with the significance and the magnitude of what those fines prove to be in the other jurisdictions around the world that can be identified. If we just take the GDPR regulations as an example, we're talking there about 4% of global annual revenue, or 20 million euros, whichever is the higher in that particular instance. So it would be dependent on the magnitude of the breach, the complexities of the breach that exist, perhaps the number of transgressions that are involved. It could go so far as to include the cooperation of the parties involved in that particular breach, and the investigation that is taking place. But ultimately, a data subject could potentially seek compensation in respect of a breach having occurred without their consent and without their permission. So it becomes critically important that we identify with some of the breaches that are ongoing at the moment. There's lots of cyber attacks that are communicated in the media at the moment, and what the magnitude of those cyber attacks are. The potential consequences that could come from something like that is significant, and for that reason, we'd like to state here out that it should not be understated in terms of what the monetary impact on any business could potentially be in the event of a breach or a unlawful processing of information incident that may be occurring. So your response plan should include cyber security measures, data security measures. It should include an incident management response plan, protection of personal information management plan. So there are a number of items, and if you're a client of the compliance toolbox, you'll have already received from our offices a POPIA toolbox, giving you access to guidelines and templates and some stationery that you could use and customize and remarkably tailor to the operational requirements of your organization as a point of departure. It's inevitable that those policies will move. They will evolve over time as you start to get deeper into the legislation and deeper into the practical requirements operationally of the organization, and move forward. And therefore, it is expected that this is not a once-off construct in your response plan. This is not a once-off development of a policy, but rather a point of departure with the intention to review it regularly. Early on, we would suggest touching base with your response plan and engaging with your task team responsible for the management of the POPIA regulations in your business, so that at least on a quarterly basis early on, you are reviewing what you've got against what there must be, and identifying any controls that need to be enhanced, and allocating the necessary responsibilities and accountabilities that go with that, to ensure that you're keeping up and keeping pace with the evolution of what we will expect to see in respect of POPIA. Very quickly over the next few slides, we've just kept a timeline in terms of where the POPIA Act in fact started and where it is now today. So the law was ratified back in 2013. The announcement on the 1st of July 2020 confirmed that the Protection of Personal Information Act has officially come into force. On the 1st of July 2021 was the expected date for business to meet compliance in terms of the regulations. And it was also the date upon which the enforcement powers were granted to the information regulator. It is important to understand throughout the construct of your response plan of the organization that it is not always necessarily going to be a case of the location of the data subject, but it will always be a case of where the data is being processed. So if the data subject's information that you're using and processing on an ongoing basis is processed only within the borders of South Africa, you would need to deal with POPIA, you would need to deal with the generally accepted standards as far as data security is concerned. It is important that you focus on the local regulations. However, if you're a financial advisor and you are opening an investment opportunity with your client beyond the borders of South Africa, for example, you're opening up an offshore investment opportunity for your client, so you would have to understand, firstly, that the jurisdiction in which you're operating in terms of that particular client or where you are processing information does offer you the same assurance of the same data protection standards that you would need to comply with in South Africa. So you've got to do, it would not just be POPIA that is triggered. You may have to seek guidance from the Gdpr or the data security regulations and provisions from the foreign country that you may be investing money in and processing your client's information in to set up the offshore investment and the monitoring thereof on an ongoing basis. So it becomes, again, a significant conversation as far as that is concerned. We continue to speak about accountability, transparency, security, data minimization or classification more specifically, purpose limitation. So is the information that you're using, is the whole set of information that you're asking from your clients, is it fit for purpose? Is it limited to the purpose that you require that information for, or are you collecting more than perhaps you need? And then ultimately, the biggest focus and the highest regard that we need to have is the rights of data subjects. So this is information that belongs to the people that you're doing business with or to the businesses that you're doing business with. And ultimately, their rights need to be protected, and the assurances and the necessary safeguards need to be applied to make sure that they take comfort in the fact that you are using the information, processing personal information in respect of their specifics, but hopefully largely ordinarily in the course of performing the duties that you set out to serve your clients under. When setting up your task team for the organization, it's important to go through a brainstorming exercise, and we feel that there are some high-level topics that can be dealt with in a brainstorming session with the allocated task team. And it should deal with items like rights of access, consent requirements, non-compliance implications and who is accountable, the rights of the public and general consumers, the information officer, the appointment of that information officer, the role that that person will take on, and whether or not there will be a deputy information officer involved in the process so that some of the responsibility can be shared, but ultimately accountability retained at a very high level. Privacy policies or statements could be constructed. So on the basis of looking at the GDPR, the privacy policy is a document which business can use in its simplest form to communicate the use of personal information in respect of data subjects and the processing thereof in a very well written privacy policy or statement, which you can then send out to your clients. General discussions around data security and the generally accepted standards that need to be understood there. So there becomes an opportunity to invite the IT department or IT specialist set of skills that you might be employing inside the organization, the definitions of personal data that you're using in the business, reporting of actual or potential breaches. The legislation is a self-disciplining piece of legislation. It relies very highly on the honesty and integrity of business in general and representatives of business, that if there is a breach and there is a suspected breach potentially, that a necessary report is communicated and then submitted to the regulator's office as a starting point, and then dealing with the data subjects who may be involved, who may be impacted through a potential breach or an actual breach that exists, to tell them that you've identified the breach and tell them what the actions are that you are taking to restore the integrity of compromised data or compromised security portals that might be existent in the business, but ongoing communication until those matters are resolved. and ultimately restoring the integrity and the comfort of your data subjects where there has been a breach. The legalities for processing information. So what happens if you are potentially processing information unlawfully, or are you processing it lawfully, set out by tying it back to the legislation and the provisions thereof. Looking at email or direct marketing, what it means in that, what are those initiatives? How are those initiatives impacted in the organization when there is a need to communicate a marketing campaign, and how may it impact the business if perhaps you haven't formulated a response to that particular item constructed from the legislation and the requirements there too. And then data transfers. So a data transfer could be to a product supplier or another service provider in the supply chain of delivery of service to your particular customer, that may require specific consent. It could also mean data transfers cross-border, where perhaps you passing information onto a university, for example, for statistical purposes or research purposes, thus ultimately feeding the strategy of the business. But I mean, you'd have to, in your own sense of your own business, understand if data is being transferred, where is it going, and is it necessary to go there, and is it being done lawfully, and are the relevant assurances and safeguards in place as far as the data security measures are concerned, and does that satisfy you in the construct of what you need to comply with, based on your risk-based approach of your organization, and does that then get to a point where everything is lawful and above board? It's important that where you are talking about these things, where you're making enhancements, where discussions are happening, that you keep a documented trail throughout the organization as to when items are being monitored, tested, changed, enhanced, improved, maintained, whatever the reasons are, but that you have an audit trail basically, or a document trail that continues to demonstrate your commitment to meeting the obligations set out by the regulations, and on that basis getting to a point of compliance. You want your compliance to be as close to 100% as it is possible, but because this is potentially a moving piece of legislation and business will move as the requirements of the legislation need to be met, it is almost impossible to have compliance at a 100% level. But it is important to demonstrate that you're meeting compliance at the highest possible level of the organization. To touch on the 8 conditions for lawful processing of personal information, all responsible parties must ensure compliance in terms of those 8 conditions. And we're talking here about accountability. We're talking about processing limitations, much of which we've mentioned already. Further processing limitations, purpose specifications, so classifying the data that you need, ensuring it is fit for purpose. Information quality. It's important that on at least an annual basis that you invite the participation of your data subjects, and therefore we're talking about data subject participation as well, to keep information up to date and to renew any consent or permission that may be required to use their personal information on an ongoing basis, in particular with reference to special or sensitive personal information, but not necessarily excluding ordinary personal information on an ongoing basis. So again, your best defense, as we say, is consent and demonstrated permission that you are using information on a lawful basis. But the information quality aspect deals with bringing it up to date. Many data subjects may not necessarily keep their information up to date from time to time. And on that basis, it becomes important that you invite the data subjects to update their information, keeping it up to date, ensuring the quality of the information is what it is to be, and ultimately obtaining that permission and consent on an ongoing basis. Please understand early on that consent is not implied and it is not indefinite. So it's important to have an understanding that at any point in time, the data subject could remove permission to use their information, or they could revoke any consent that they have given at any point in time, thus limiting any further use of their personal information for any purpose that you may be holding that information for. And then finally, dealing with the security, privacy, and data protection aspects of the information, of the data subjects in your possession, and making sure that all of the 8 conditions for lawful processing of personal information is then complied with throughout the organizational structures. When we are talking about processing of information and limitations there too, so we spoke already about understanding that personal information relating to individuals or companies or other organizations may be ordinary personal information. It may also be sensitive or special personal information. And particularly with sensitive or special personal information, it's important to have specific consent. And in the sense where you may be processing information in respect of children, specifically the age of 17 years or younger, you may need the consent of a competent person, being a parent or a legal guardian, that can understand the purpose for the need of that information being processed, and thereby giving the necessary consent that may be required. But it's important that we, in this particular segment, we've highlighted what we believe are 7 pillars of focus in terms of processing of information and the limitations thereto. And the first would be to always process information lawfully. Number 2, to process only what is relevant and necessary. Obtain prior consent or permission. So talking about, again, inviting the data subject's participation, but always your best defense being the consent or the permission that you can demonstrate has been obtained, being a case of a defense in the event of there being a breach or a potential complaint where there is a sense of a breach that is brought to you by the regulator or brought to your attention by the regulator's office. Number 4, collect information only from the person or legal person concerned. Okay, so we're talking again from the data subject and natural person. It could also be a business entity, the responsible parties of the business entity, so to speak. Number 5, the use of information must absolutely be for its intended purpose only. Point 6, take reasonable steps to keep information up to date. And point 7, as we've already said, record or document evidence that all reasonable steps have been taken to ensure the security of that information, the safeguards and the integrity of that information, and then to avoid breaches. So that comes again in the whole construct of your response plan as a responsible organization, is to ensure that no unauthorized use or unauthorized access is possible through the control measures, the risk management techniques that you're using in response to the obligations set out by the regulations. The next slide, we've spoken about some of already in the last few comments and in the last part of the presentation, but part of the CTB POPI Toolbox is offering you to construct a POPI management policy, a protection of personal information management policy. And really what this policy will deal with, when we look at the definition again in terms of POPI, just keep or remain mindful that it is to protect people from harm by protecting their personal information, to stop their money from being stolen, to stop their identities being stolen, and generally to protect their privacy, which is a fundamental human right. So it's important that you understand always what information you are using. I mean, if you were processing and holding in your possession bank account numbers of customers, and with that ID documents, potential digital signatures as an example, given that many businesses are embracing this digital space or this digital era brought on by the pandemic that we've all been enduring for the last 18 months or so, it becomes important that we understand that a breach is possible. We've got very, very clever individuals, or more specifically criminals, out in the market that may want to seize that information or access that information in return for a ransom or monetary amount to give back that information. So we've seen it time and time again. There's been a number of breaches that have been communicated in the media, and largely it's almost a set of criminals or very clever individuals that are able to access information, hold information hostage, if you will, with then a request for a ransom amount in order to return that information. So it's quite important that you understand that it is possible to find yourself in a position where there has been a breach. If you're regularly testing your backups and your security measures from your IT structures or platforms, it's important that one understands that you might even identify that there have been attempted breaches. But if they have not been successful, then at least you understand that you can take a sense of comfort and confidence in the construct of your IT protocols and the response plan as far as data security is concerned. But on this particular slide, we have to offer extra attention to sensitive personal information or special personal information to ensure on an ongoing basis that the need for that information is fit for purpose and that you understand whose information you're dealing with, what you're dealing with, when you're dealing with it, where, why, and how. And here are examples on these tabs, in particular, the tabs in red. Amounts to the majority of information that could be construed as or deemed to be sensitive and or personal information. So again, very important to go down that road and understand that in the construct of your response plan, that you're dealing with your data classification. Classify the information that you need and rid the system, as long as you're complying with other provisions of other laws that might be imposed on you for record keeping purposes, that you rid the immediate systems from the use of unnecessary information or information that perhaps is not needed. We spoke earlier very briefly to introduce consent and privacy policies more particularly. And what we have referenced here is to say that generally you do not need to obtain consent to collect information, personal information that is, unless you are collecting sensitive or personal information, special personal information. So that is a little different to the GDPR. So if you go and reference that particular segment of the GDPR, you'll understand as a guideline or a guidance note more specifically, that by applying the GDPR standards, perhaps would help you respond better in the situation in respect of POPI. We expect that because there's little case law tried and tested in South Africa as far as the protection of personal information is concerned, there's lots going on in the social media space. There are documentaries referencing, so the names of two documentaries I've witnessed or gone through myself are the Social Dilemma and The Big Hack. So those are documentaries that are available on Netflix, if you will. And if you're a visual person like I am, please take some time to go and watch those. And I think you become surprised as to how much can be done when somebody has possession of your personal information. As an example, if you want your privacy is respected in your general life and in your personal life, having a lot all over Facebook about your personal life, about your successes, about your family, your children, where you visit on a regular basis. By putting it all out in the public space, you're almost foregoing the privacy that you would hope to expect that you are entitled to in the provisions of law. But if you're putting it out in the public domain on a permanent basis or an ongoing basis, you're opening yourself up to less privacy and less privileges as far as privacy is concerned if you're a very socially engaged individual as far as these social platforms are concerned. So be very careful about what you do out in the domain, what you share over WhatsApp messages. I mean, any of that could be construed processing of your personal information in the wrong light, in the wrong context, and in respect of the wrong people. You could find yourself wanting in respect of the law. So be very careful about that. We spoke about specific consent rules in relation to children, so that under the age of 17 or under, you need the specific consent of a competent person, or i.e. a parent or appointed guardian. One may only process personal information for direct marketing by email, telephone, or SMS, where the data subject is a customer or has given consent to processing of his or her or their personal data. Customers must always be given the opportunity to not having their personal information processed. They must also be granted access to the details that must be provided to customers in respect of how to opt out. So if you have steps 1 through 3, how to opt out of your marketing list. Number 1, an opt-out cannot cost your data subject anything. So an SMS campaign that says opt-out should not relate to charges in the domain of the data subject. It could be a simple unsubscribe from a communication list, or it could be a simple revoking of the consent that may be implied at any particular point in time, bearing in mind that we've already said that no consent is implied. Consent is explicit, and you'd have to demonstrate that you're doing so lawfully. So many have built businesses in their time, in their careers, where they have built a database over the many years in the success of their businesses. And now it becomes critically important to have this opt-out of functionality, or the option to remove from a list, or unsubscribe from a list of communication or marketing campaigns and so forth. So critically important that if that is what you are using to communicate with clients and or potential clients at this stage, that you incorporate an opt-out function or an unsubscribe function that you're not found yourself wanting any longer in terms of the law. Perhaps it hasn't been so relevant to date prior to the enforcement of the law, but it becomes significantly important going forward. Certainly if there was an inspection of your response plan to POPI, one would have to be able to witness, and you'd have to be able to demonstrate that the unsubscription request or opt-out request actually works, because there's also the issue of the unsubscribe or the opt-out being requested by a particular client and then finds themselves still being communicated with next month, the following month, the month thereafter, and eventually results in a complaint against the business. So please be careful how you do that, and if anybody's monitoring those campaigns, it's important that they adhere to the provisions of the legislation in terms of those campaigns. So customers must also be given the opportunity to not having their data processed. Okay, so up front you can say, you can write one communication and say, so and so, dear customer, we'd like to communicate with you on a regular basis. We collect your information via our website. This is what we do with it. This is how we use it. Perhaps it is target marketing that you're making use of, but you could also start with an option to the client to say, can we keep you on our list for communication, prior to simply sending the next communication with an opt-out function. So again, there are different methods that different businesses will use, and again, no one business needs to do it the same way. It's not very prescriptive as long as compliance obligations are being achieved. So the legislation must be complied with, but how you do it operationally and functionally will be fundamentally, potentially different from one business to the next. There must be transparency in the process. So who are you as a business? So the data subject receiving your correspondence or communication must understand who is communicating with them, what information you are looking for, what information you collect, what information you are using, why you are using, and ultimately be mindful and perhaps remind the data subject of their rights. It's always important that as responsible parties involved in business, involved in the financial services industry, but also not limiting to the financial service industry, that sometimes the duty is imposed on you as a responsible party or responsible business owner, that you educate the general public, be it a existing client or a prospective client, but to keep that program of education available in the event that somebody perhaps doesn't fully understand their rights. And you can do it in a meaningful manner and in a subtle manner enough, to continue the relationship that you keep building with the general public for purposes of doing business, or whatever the purpose is behind communication with general data subjects, or end to end. The most practical way to provide information, we said this earlier, the most practical way to provide information is to incorporate it into an organizational online privacy policy or statement, okay, as well as any other organizational functional documentation. So earlier we spoke about mandates, agreements. You can talk about memorandums of understanding, memorandums of incorporation. We can talk about different levels of agreements, and we'll touch on one later on in the session, which is really because many of our clients are largely involved in the financial services space. We're talking about something called a mandated intermediary agreement, but it could be a simple terms and conditions or a service level agreement, or as we said, a memorandum of understanding of sorts that incorporates all of the requirements that need to be communicated to the data subject in question. And that on an ongoing basis is then worth reviewing and keeping up to date from time to time to ensure that clients always have the information that they are needing. There are legalities for processing. So again, we said very quickly, to collect information, you might not need consent. But the moment you do something with that information, example, store information, it becomes processing of personal information, and thus the 8 conditions of lawful processing of personal information are then triggered and must be complied with. Lawful processing includes consent for specific information, data storage, data security, data transfers, rights of access, rights to correction and erasure. And in specific instances, you're only able to collect information from the data subject themselves and then consent. So you can see that we can, through our conversation, we keep bringing back the and then consent. So it's always your best defense will always be consent or permission that you can prove or demonstrate as to the reasons why you're processing a data subject's information. And hopefully, in every instance, it's in the ordinary course of performing the duties and the deliverables to the data subject or prospective clients that you are acquiring in your business. There is the basis of a legitimate interest, which is a legal basis or a defense as to why one would be processing personal information. It is very light in the context of the regulations of POPIA, but by its very definition extracted from the GDPR, legitimate interest is the most flexible of the GDPR's lawful basis for processing personal data. Theoretically, it applies whenever an organization uses personal data in a way that the data subject would expect. Interests can refer to almost anything here, including an organization or third party's commercial interests or wider societal benefits. So organizations that choose to use legitimate interest as a basis of processing information lawfully must be able to thoroughly justify it throughout their business documentation, end to end. Unlike other lawful bases, it is not obvious how this particular condition will apply, okay? Unless you can substantiate your reasoning sufficiently, data subjects will be able to still object to the processing of their personal information and force you to remove their records from any use whatsoever. If they disagree with your justification for legitimate interest, the burden is on you to prove otherwise. Okay, to use the basis of legitimate interest as a defense for lawful processing of personal information, there's a 3-part test that must be satisfied, and all 3 parts of the test must be satisfied, not just one. So legitimate interest will always, in the first instance, deal with a purpose test. It will then deal with a necessity test and then a balancing test. But I want to say up front and outright that no business should seek to use legitimate interest as a default reason for processing information lawfully without trying to find other methods to obtain permission and or consent from the data subjects to use their information on a lawful basis for the purposes specified and required in the construct of your duties to your customers or the construct of processing personal information lawfully as set out by the obligations of the legislation. Right. Now, I'm not going to go through the next few slides in too much detail. I really just want to give you a basis of understanding and legitimate interest in the purpose test. The purpose test will help you decide whether the processing can be considered a legitimate interest. So there are many questions coming from different businesses, and particularly with reference to business development consultants in the nature of various different businesses. And ultimately, a business development consultant will need a set of information in order to develop a strategic proposal or a value proposition to their customers. And ultimately, It may not always be practical to go to each person whose data may be involved in constructing that strategic proposal or value proposition to obtain consent. So the element of legitimate interest may certainly be possible, but it's important that you qualify that against the legal tests that are concerned here to understand, is it possible in that way? Is there a legitimate interest to process information for that purpose? There are a number of questions, and again, not limiting. You can become quite creative in your test questions as to why the purpose test is possible to be satisfied in what you are doing in the purpose for processing that personal information under the pretense of a legitimate interest. The necessity test will also then help you decide whether the legitimate interest is the most appropriate lawful basis for processing of personal information. Again, there's a number of questions that you can ask to satisfy whether the necessity test is complied with and is lawful, as satisfying the second test or basis of legitimate interest. Going then for the last test, the last prong, the legal prong for legitimate interest is the balance test. And here, the balance test will help you decide whether the data subject's interests override the legitimate interest. So there are again a number of questions that you can ask to determine, are you able to satisfy the final balance test, and ultimately the conclusion being that a legitimate interest may exist, and therefore it is the legal basis under which you're processing information lawfully. Important to note that our advice, we've said, don't use legitimate as a default, legitimate interest as a default, but avoid legitimate interest as a lawful basis if you think people might object, if you think people won't reasonably expect you to use their data for your purpose as intended, that you think people won't understand why you need to use their personal information, or perhaps don't understand why you need their consent, and if the data processing could cause any kind of harm, for example. Quite important on that basis that one recognizes, that legitimate interest may not be the most straightforward of options, and the basis of which you are processing personal information. So again, that becomes a critical element in the response plan and the compliance framework and the risk management plan that you're constructing for the organization to meet the obligations set out by POPIA. We've spoken already in some detail about data security. What is important is that business that is involved in processing of personal information, or business that holds personal information of data subjects in its possession, implement practical but appropriately technical and organizational controls to protect the personal information of the subjects in your possession, to customize security controls, as well as measures to subject to the nature of the personal data process, based on the complexity, based on the significance of the personal data being used. So, for example, heightened or enhanced controls should be afforded to banking information, ID numbers, perhaps personal or unique identifiers in respect of data subjects. That becomes critical in your response plan. So you can consider the impact through the construct of these measures, to consider the impact of the potential breaches that could exist. If you're a smaller business, a medium business, or a large business, determine project manage or determine the implementation costs that may be required to set up a sufficient response plan as far as security controls and measures are concerned. You can use methods such as access control. Particularly in the time of the pandemic, many businesses have forced employees to work from home. So you've got to articulate in your response plan the control measures for safeguarding of information, or continued lawful processing of personal information, both on-site and off-site. It's quite easy for somebody working from home to not have a dedicated office space, to sit at a dining room table, make notes in hard copy on a notepad, which may deal with very relevant, very pertinent information in respect of a very significant customer. And who knows where that information goes to. Visitors might be coming on and passing through that home. And on that basis, the information that is written on a notepad in hard copy is in sight of the public eye. nothing stops anybody from taking a photo of a notepad if they are nosy in any way. So you've got to start considering the on-site, off-site ability to manage and control the lawful requirements for processing of personal information, storage, access control, and or future destruction. So we're also talking about safeguards like a company controlled VPN that is being used by the individual working from home. Sometimes the Wi-Fi or fiber solutions for interconnectivity may not afford the relevant safeguards or user controls or access controls or security measures that satisfy the organizational compliance structure. So very important to go beyond what exists only in the office space. And then, as we said earlier, to consider and become familiar with generally accepted security practices and procedures as far as data security is concerned. Data transfer. So POPIA prohibits the transfer of data beyond the borders of South Africa specifically. Cross-border transfers, however, to a third party are permitted where the third party is subject to legal or corporate data protection rules that can also afford you and your clients, the data subjects, the same assurances of the data privacy and safeguard requirements and the assurances required in the generally accepted practices are concerned to give you comfort and confidence that there is adherence to the provisions of regulations and that any undue harm that your customer or yourselves might be exposed to is then taken care of, and there is an official responsible response to that in the event that there could be a breach or a compromise of any sort. Certain transfers are exempted in the provisions of the Act. Transfers where the data subject has consented to the transfer or where the transfer is necessary to fulfill a contract. Again, in the construct of the business that you will do or the interactions that you will have with customers, it remains that the best defense will always be consent. So back to a mandate or a contract or a memorandum of understanding or a service level agreement or a privacy policy, one could consider making provision for the possibility that a cross-border transfer may be necessary to satisfy a specific need in the event it was necessary for your data subject that you are handling business with. So again, very important to consider your response plan in respect of data transfers and ensure compliance with the regulations imposed on the business. Rights of access, quite an important one. Any data subject at any point in time would have the right to accessing their information, to correcting their information, and also having their information erased from your immediate systems for any given reason whatsoever. The public in general and a consumer as such has the right at any time, free of charge, to request whether you process their personal information. And a simple yes or no is reasonable in the sense that they're simply asking, do you process any of their personal information? And you've got to offer that response with honesty and integrity, and you've got to offer it free of charge. Okay. However, there is something that we refer to which is a data subject access request, where a data subject or a client that you might be doing business with, or a client that is on your marketing list, or a future client that you are communicating with in the hope that they would be doing business with you, at any point in time could request a record of that information that you're processing. And at this point, it is important that you note that you can charge a nominal fee. Generally, I've seen fees that are starting at around 30, 40, 50, 60 Rand, going as high as sort of 120 Rand. And it all depends on the complexity of the information that is being asked for. It is also dependent on the time that may be consumed to prepare the record of information. But at any point in time, should you decide to charge for the preparation of the record for the data subject having requested such, you'd have to provide a cost estimate before you provide the service. And upon acceptance of that estimate, it is then important that a reasonable time frame be communicated to the client to respond to such request. So normally, anything within a reasonable time frame. Remember, the relevance on the whole part of the legislation is what is reasonable, and generally as a guideline, reasonable in terms of something like this, again depending on the magnitude of the preparation of the record, would be not longer than 30 business days, or excuse me, not longer than 30 days. But ultimately, if you can get it done before something becomes a complaint, you would hope to do something within 7 to 10 business days that will then help and satisfy the requirements of the data subject request. So please keep in mind that that is quite important, and on an ongoing basis, you may need to review that from time to time. We've seen larger businesses are taking the time to put together a schedule of fees on their public domains, which already in advance tell a customer what they might expect to pay for a record of the information that a responsible party or an operator is processing in respect of that particular data subject. However, many of the smaller businesses, and certainly businesses where they hope to continue to hold a relationship with a client, or where they're earning fees from that client in relation to the business relationship or the services being rendered, we've also seen that many businesses are not charging for this data subject access request, the information request, or the preparation of the record on information that is being held of the data subject. So, all unto their own. Different businesses will do these things differently. And again, it's not very prescriptive, but it's also important that the fee that is charged is not of such a nature that prohibits the ability of the data subject, number one, to pay for it, and therefore then to access the information that they're requesting and rightfully entitled to. Right, so that becomes significant. We did indicate right in the beginning of the presentation that it is mandatory to appoint an information officer. Larger businesses, it is also encourageable to appoint a deputy information officer to aid and allow for a delegation of certain responsibilities, but certainly in no shape or form would the information officer being appointed relinquish any accountability. And it was envisaged at the 1st of July that all businesses would appoint their information officers and register them on the information regulator's website. Now, what has since happened is there's been lots of traffic flow on the regulator's website, to the point where not everybody has been able to successfully register their information officers. And so many have taken to action the manual procedure of appointing an information officer by completing the manual form and submitting that by email to the information regulator's office. And that information is available on the information regulator's website. It is also important to conclude the appointment of an information officer for business in a formal or by conclusion of an appointment contract, which then supplements the employment agreement for that particular individual. As we said earlier, in the absence of a formal appointment, the role is automatically imposed upon the head of the organization, and an example being the chief executive officer. So the registration of information officer has set out, or the regulator has set out guidelines in terms of the responsibilities of information officers in section 55.2, which then communicates that the responsible parties must register its information officer before taking up his or her respective duties and or responsibilities. But there are draft guidelines available in terms of what has been developed by the information regulator, so that anybody who is appointed in that role is then able to lean on guidelines for their responsibilities. But please note, there should also be a particular competency inside the organization where the role is developed on an ongoing basis for the individual concerned. So there are a number of webinars, seminars, conferences, certification courses, foundational courses that do exist. There is reference to some of the programs available for the development of the competencies of an information officer through the Information Officers Association of South Africa. So you can visit the Information Officers Association website, and you'll be able to find there some information in respect of right through from the foundational course to a particularly to a course offering certification of an information officer for the organizations who require this. Basically, all organizations requiring the appointment of an information officer to develop the role as a core competency for the benefit of the organization. It is important to consider possible arrangements for an information officer. And what we've seen in the market is, upon the enforcement date of the regulations, that many businesses and or experts have popped up in the media space, social media space, reflecting that they are able to offer expertise to business, either as an external appointed information officer, or certainly giving consulting and guidance and support from an external expertise suite that is available from various organizations in the market. However, our advice and our independent opinion, and very much aligned with the legislation, is that the information officer appointed should be a person of senior authority within the organization. And it's ultimately got to be somebody that is operational fundamentally in the organization, and therefore responsible for the response plan to the Protection of Personal Information Act and the arrangements there too. But businesses will either lean on the fact that the CEO will assume that role and functionality. Businesses will also appoint an information officer in respect of POPIA. Businesses will also have potentially a separate information officer for PIA. And then also you might have an information officer appointed and responsible for both POPIA and PIA. So it's quite important that, again, we just make note that the functional, operational, and practical requirements of any organization will determine the hierarchy, or in more specific terms, the organogram of the organization, and who the information officer will be and should be, and where that responsibility sits and where the accountability rests. But again, let's not be short-sighted in terms of this is a key role and must be developed as a core competency internally for the organization. Ultimately, the qualifications, qualities, and attributes must be a leader with integrity, that is responsible and instrumental in the role of the organization, has good communication skills, has a thorough understanding of data protection and related principles, has operational knowledge of the business and the data it holds and processes, and then ultimately someone that is skillful and knowledgeable in tech, general technology, and can keep abreast of the ongoing technological advances that may exist in the market and or in the industry, depending on where the business finds itself. Outlined in the legislation, Section 55 of POPIA and the POPIA regulation sets out the responsibilities of an information officer. And yeah, we've just documented some of them. Please, this is not an exhaustive list in any way, shape, or form. The full responsibility and accountability of the response plan, the maintenance of that response plan, the ongoing monitoring of the success against that response plan of business in general, the enhancements and further development of the response plan and compliance framework rests with so all end to end, that responsibility rests with the information officer of the appointed person in any organization. Penalties for non-compliance, we've already made reference to earlier on, and the maximum financial penalty at this particular point in time is 10 million rand for an infringement in respect of POPIA. More serious cases can see individuals sentenced to 10 years in prison and ultimately with criminal records, but sanctions in respect of POPI may also include other offences, hindering, obstructing, or unlawfully influencing enforcement officials, failing to attend court proceedings or inspections, lying under oath, as an example. Enforcement officials may also consider the degree of cooperation shown by the parties during investigations to then finally issue a reasonable penalty based on the findings of a breach or an infringement against the law. So very important that that one keeps mindful of the fact that you are personally accountable in the event that there's a breach or compromise or knowledge of a potential breach that could come from business or could be imposed on business for non-compliance. So, from that perspective, quite important. Again, breach reporting, the legislation is a self-disciplining piece of legislation or self-adherence piece of legislation, and you're it at the end of the day. You must notify the information regulator and individuals affected by a breach or a compromise of their information having been accessed and what set of information has been accessed. So the first is, and generally we're saying within 72 hours of knowledge of a breach or a compromise or the potential of a breach or compromise, that you notify the regulator and then notify the data subjects that may be impacted through that breach or compromise. Your integrity is imposed on you to make that report. And please understand that the accountability remains with the CEO of the organization by default as the information officer, who may delegate that responsibility, but not the accountability. So the CEO of any organization may appoint officially an information officer for the organization, but will never relinquish their accountability. So this is a very significant role operationally and functionally that any individual could accept as a part of the response plan of the organization in respect of POPIA. And very important that they're knowledgeable and technically able to deal with the aspects that come with various situations or scenarios that may result in a non-compliance factor or a non-compliance risk event that could occur in business, and therefore any impact, both financial and criminally, could be imposed on the organizations, the leadership thereof, and the responsible persons for the role and the function of the organization. We spoke earlier about a mandated intermediary agreement, and this is largely, probably more specifically, in the financial services space. It doesn't have to be limited to the financial services space. The mandated intermediary agreement would not only deal with the intermediary appointment, but it would also be able to deal with clarifying information, personal and or sensitive information that may need to be used and processed from time to time to perform the service or a contract with your customer. It also serves as an opportunity to obtain consent, perhaps for a definite timeline, or for a agreed ongoing basis until such time that consent is revoked. And furthermore, it gives you the opportunity through a document of sorts, and we're not necessarily limiting this conversation to a mandated intermediary agreement, but to clarify with clients the roles, the responsibilities, and the deliverables of the parties to the business relationship. Conclude the mandate. So it could be an SLA, contractual terms, memorandum of understanding, a service level agreement. Conclude the contractual terms of the business relationship. And this document may incorporate the need to process and or sharing of personal information, and then conclude with consent. So again, we bring back the best defense being that if you can conclude with consent and you're able to demonstrate that on an ongoing basis, and we've got to remain practical, we've got to remain reasonable in business, because the extent to which one may need to comply or one may choose to comply would also then have a hindrance on the business to continue to do business as freely and as much with ease as one has been used to, without creating too many barriers in the process to comply. It is important to comply, but what you've got to understand is there's an element of reasonableness that one would need to consider in that response plan. So as long as you're doing everything reasonably possible to afford the data subjects the privilege of the safeguards of their information, the protection of their information from unauthorized access or unauthorized use, but ultimately maintaining a level of consent and or permission to process a very specifically classified set of information in respect of your data subject, then you should have no problems. But it's important to remain compliant, yet practical and reasonable, to ensure that your business may continue as it always has whilst you comply. We spoke earlier about the information officer having been the role needing to be developed as a core competency for the organization. So education and learning of an information officer. Online information is regularly available. Lots going on in the market as far as the media is concerned in terms of online information. Ongoing workshops are available. Organized conferences are available. We suggest at the very least the enrollment of the information officer on a skills and techniques program, or obtaining the highest level of certification in respect of the information officer, sort of being call of the day in terms of accepting that role and responsibility for the organization. So it is important that one remains mindful of the fact that this must be a core competency. It must be, the technical ability must be imparted on somebody. It must be inherent in somebody to remain a critical component in the response plan of the organization's compliance in respect of POPI. Right. Furthermore, in the POPI toolbox that is available through CTB, here is a compliance POPI checklist dealing with 3 pillars of focus: collecting of personal information, handling of personal information, and then storage of that personal information. So that on an ongoing basis becomes a real significant conversation, and there's a drop down of considerations on the slide below that one could focus on and remain mindful of, again, in the construct of your tools, your templates, your methodologies, your response plan, your action plan, your risk management measures and techniques, your controls that you're implementing, and ultimately your compliance framework, bringing all of this together in terms of how you as an organization involved in processing personal information will remain compliant on an ongoing basis. Here is a sample of an impact assessment. So not only do we believe that your first steps in this regard are going to be the appointment of an information officer, so really deciding with some significant consideration who the most appropriate person will be for the organization to take on this responsibility, then to devise a privacy classify the data you are using and incorporate that into a privacy statement or policy, which is then communicated to clients and or made available on a public domain, for example, a website. It is also then to further continue your response plan by doing a sort of due diligence of the organization, an impact assessment of the organization. The next few slides in the presentation gives you an outline of an impact assessment that we've included in our POPI toolbox for our CTB clients. And on that basis, again, this is not a rigid impact assessment. This is merely a guideline and can be tailored specifically operationally and functionally to the nature of your organization, and give you an idea of the items to think about in the construct of your response plan and so on. So the next few slides deal with exactly that. There is also in the POPI toolbox an outline of a compliance framework that will enable you to identify the pieces of the legislation that are not only most relevant, but all of the pieces of legislation are relevant. Certain things like direct marketing. If you're not a business that does direct marketing, the segment for direct marketing would not necessarily be imposed on you and therefore may not be applicable. But what you can be doing here is you can give reference to the provision of the legislation. So the piece of the legislation, what are the risk or causal factors that could cause a risk event to happen in respect of that piece of the legislation? What is the inherent risk rating of the business? Is it high? Is it moderate? Is it low? What are your existing controls, if any? What is the remaining risk after your existing controls, if any, have been applied? Your risk measures, your techniques. If they've been applied, is the risk lower than it was in the beginning after considering those controls? And are there additional controls that have been identified that may be necessary for implementation? And then furthermore, and finally, who is the responsible person to take care of the controls and the testing of efficiency, adequacy, and ultimately, the testing of efficiency, effectiveness, and ultimately adequacy in respect of the new controls being required, and by when do those controls need to be implemented, approved, and achieved. So the framework that we see here is just a sample to give you a guideline in terms of how you could potentially use a risk management plan to meet the obligations that are set out by POPIA. So that becomes a real significant conversation. Every business not only needs to comply with POPIA, but must have a compliance framework that sets out the actions taken by the business to respond to the provisions of the legislation, to make sure that you are acting lawfully in the context of the legislation should it be tested against the business. So on that basis, a real significant conversation in the engagements within the organization with the task team that will be responsible for this, and ultimately the decisions finally resting with the information officer to decide instrumentally how the business will respond. On that basis, so that we continue on these last few slides, we thought it'd be interesting to include for you this particular URL link. This has been written by a particular author, and if you go and look up the URL, you'll find who the author is. But what was interesting is you could punch in your email address on these particular screens that you can find on the link provided on this particular slide. And you may find that your email address, current, past, or future, well, current, past, or any other email address that you might be using may have been breached previously. Or not. So you could be one of those individuals that comes out on the left-hand side having a breached email address, or an attempted breach, or somebody on the right-hand side. The right-hand side really is somebody who's got a brand new email address, using it for the first few weeks, and may certainly not have that response on the left coming out. You'd likely have a green response saying that you have not been, your email accounts have not been breached as a result. But do yourself a favor, visit the URL link on this particular slide, and go and read up about the author and what he's gone through and what he's witnessed and what he's done, resulting in the need, in his belief, to provide for this particular instrument on a public domain that can be used from time to time to identify any data breaches that there might be. If your email address has been breached, you'll be given the option to register to obtain information of where that information of the email address has been breached or attempted to be breached. Anyway, it is quite interesting to read up about it and understand exactly where that is from. So that is a nice rounding off to the content that we have provided. So, ladies and gentlemen, it's been an absolute privilege for me to have you online. Please feel free, as our clients of CTB, to reach out to us as you may wish from time to time, and on an ongoing basis seek guidance from various sources that may help you improve on your response plan in respect of POPIA. Thank you very much. Have a great day further.